Hello, welcome to Off the Clock Attorney Talk. I'm Scott Hislop.
And I'm Brad Crockett. And today we're going to cover our third video in our series on estate planning. We're going to talk about wills and trusts. So Scott, I want to do my estate plan. Should I do a will or should I do a trust?
That's the big question. Probably the best thing to do is figure out what a will is or understand what a will is and what a trust is. What's a will? A will is a document that we create as part of an estate plan that identifies where assets go and to whom they go and who's going to help with that process. That document happens or becomes effective at our death. What's a trust? A trust is a legal entity. It's an organization or a box that we put things into, we create, it then provides for us. So there's different parties who are involved in a trust. There is the person who sets the trust up, you, me. There's a trustee who oftentimes is the same person who sets it up. And then there's the beneficiary. Beneficiary is the person who benefits from the use of the assets in the trust. The choice of what one to do really kind of depends on the circumstances that you have.
So you mentioned a trustee. What's a trustee's role in handling the trust?
Trustee has a really important role. The trustee's role is to manage all of the assets that the person puts into the trust for the benefit of those beneficiaries. Their job is to make sure that everything goes in, everything's taken care of, and that those assets that are in the trust are used for the benefit of the beneficiary.
So can the same person create the trust, be the trustee, and the beneficiary?
Yes, and most often that's the way it is in a revocable living trust estate planning scenario. Spouses will be co-grantors or people who set the trust up. They'll be co-trustees. They'll also be co-beneficiaries. A trustee, though, will change at death, right? The will document passes asset at death. The trust holds asset while we're alive. And then at death, if I'm a trustee and I die, we need to have somebody else being the trustee. If they're spouses, oftentimes the surviving spouse will be the successor trustee, the trustee who is the trustee after I die or one of the spouses dies. If both spouses pass away, there's often an alternate successor trustee, which is either a family member or a trusted person, or sometimes a professional, a bank, trust department, that sort of thing, who will be the trustee managing those assets for the beneficiaries.
So if I do a trust and I put my assets in there and I've got myself as the trustee and the beneficiary, do I need to have a will in that case?
Yes, you do. The short answer. There's always going to be a follow-up will or what they call a pour-over will, and that will is designed to catch any asset that I fail to or forget to put into the trust in my estate planning. If, for example, I have a trust and I forget to put my house in the trust, when I die, I need to have that go somewhere or go where I want it to go. So that pour-over will actually catch the house and put it into the trust so that the terms of the trust will then transfer the asset, my house, the way I want through my estate plan.
So when would a person choose to do a trust rather than just using a will?
It's very specific on what the circumstances are for the individual, but there are some general ideas of when a trust is a good idea. If there's assets in different jurisdictions, meaning different states, so if I have a house in Washington, if I have a house in Oregon, a trust is a good mechanism by which to hold and transfer those on my death and during my life, but on my death in particular, because then I don't have to go over to the other jurisdiction and get the courts involved. I die, the trust doesn't die. The trust still owns the asset. The terms of the trust control where that asset goes at my death. So we don't have to go to different jurisdictions and ask for permission through the probate process, which we talk about in a different video.
So what's the downsides of doing a trust?
Good question. I no longer own the asset. It's in the trust. And a very practical and real consequence is, for example, if I want to refinance my house today, my house is in the trust. I have to pull the house out of the trust, refinance it, put it back in. There's some friction costs that go along with it. In addition to the friction cost, there's an upfront cost. Trusts are more expensive to create. There's more documents, there's more work, there's more effort put into making sure all assets go in the trust at its creation, whereas with a will document, I own my asset, I create my will, I still own my asset.
So Scott, if I want a will or a trust, do I need to use an attorney to prepare that?
No, you don't need an attorney, but I strongly believe that the experience and the passion from a good estate planning attorney will make the process more enjoyable for the people going through it. as well as make it more efficient, and the end product will be or should be more complete than if you did it yourself.
Thanks, Scott. That's why we're here. We enjoy helping clients through that process. And thank you for joining us on this next video in this series on estate planning. As always, please feel free to comment, like, and subscribe.
And if you want to know more about us, look at our website, check us out on Instagram, Facebook, or LinkedIn.